The Eighth Circuit Court of Appeals has found that eviction moratoriums are likely unconstitutional. I'm Tony, and this is Real Estate Investing and Landlord News. Alright, so I have an interesting article for you today, and it's going over the recent decision from the Eighth Circuit Court of Appeals involving eviction moratoriums. Now, those of us who've been, just keeping track of all the news, and those of us who read the Fifth Amendment of the Constitution, we have believed for a while that, hey, eviction moratoriums are an unconstitutional taking of private property for public use without just compensation. So to me, it was always very, very simple, very, very, plain language that anyone could figure out. But these governments, they kept on imposing these things anyway. And, oddly enough, landlords were losing their cases in court. And, the only thing I could believe was that, hey, these are activist judges. They're far left leaning, and they think for some reason that, hey, we can just throw the Constitution out whenever we want to. That's what my big gripe with a lot of this is, okay? A lot of the stuff that happened during the pandemic was unconstitutional, We have, property rights, we have freedom of religion, freedom of speech, and a lot of that stuff was just thrown out the door just because of a pandemic. And I'm like, well, if it's the case that the pandemic we can throw this out, how far are they going to push it? Are they just going to throw it out because they don't like what you're saying, or if they don't like your religion, or maybe they want to turn this country into a communist country and just take your property away? They can try to manipulate everything so that it sways their way. If they do that, it makes the Constitution completely pointless, okay? And it absolutely absurd in my opinion. So this is a good decision from the Eighth Circuit, and I'm surprised, honestly, and I don't know how it's going to affect landlords and how it's going to affect property owners going into the future, but maybe the article will shed some light on it. Now, before I get into the article, though, go ahead, hit the like and subscribe button, maybe leave a comment down below, and let me know what you think, okay? Did you believe from the very beginning, like I did, that, hey, these eviction moratoriums are an unconstitutional taking of private property for public use without just compensation? Okay, that it seems obvious that it was, okay? We're talking about eviction moratoriums here that forced landlords to house tenants who were not paying them rent and then not giving the landlord any sort of compensation, okay? And the landlord just has to take a loss. Even in the cases where there was rental assistance, only a certain percentage of tenants actually qualified for rental assistance. So the landlords couldn't get any compensation in those cases where the tenant didn't qualify. So that, is clear cut right there that those cases in general specifically were, taking without compensation, okay? But let's see what this article says about it, because, it's a good article. So this is coming from Reason.com, and it says, Eighth Circuit rules eviction moratoria are likely to be takings requiring compensation under the Fifth Amendment. And Reason.com is it's more of a right-leaning, more conservative publication. So, they have more insight into this that isn't, so pro-tenant. And they look at it more from the landlord's perspective and from, more right-leaning perspective. This article is from April 9th, so it's not that old. So this is a relatively new ruling. So let's get into it. On April 5th, in Heights Apartments versus Walls, a unanimous panel of the U.S. Court of Appeals for the Eighth Circuit ruled that a Minnesota state eviction moratorium, enacted for the purpose of mitigating the COVID pandemic, likely qualifies as a taking of private property requiring compensation under the Takings Clause of the Fifth Amendment. They based their ruling in large part on the Supreme Court's June 2021 decision in Cedar Point Nursery versus Hasid, which held that temporary physical occupations of property qualify as per se takings that automatically require compensation. Before Cedar Point, conventional wisdom assumed that most temporary physical occupations are subject to the complicated Penn Central balancing test, under which the government usually prevails. So before that court decision there that happened in California, they thought, well, a temporary physical taking, it isn't a permanent taking. So, but now with that decision, right, that means that the compensation has to be immediate. Okay, it can't be, well, maybe we'll compensate you years down the line, and it's only for a temporary period of time from here to there, because that's what they were using as an excuse. Well, this isn't a permanent eviction moratorium, it's temporary. But then you would see that, hey, these eviction moratoriums have been going on for over a year. And then it got to the point in some places where it was over 2 years. So temporary, by some people's definition, can be darn near forever. Okay? So yeah, the court was right in ruling that, hey, these temporary, you saying it's temporary doesn't mean that this person doesn't deserve compensation. But let's continue. Here is the key passage from the Eighth Circuit ruling. Heights alleges the EOs effectuated physical takings because they forced landlords to accept the physical occupation of their property, regardless of whether tenants provided compensation. The Wall's defendants contend that no physical taking has occurred because landlords were not deprived of their right to evict the tenant. Rather, they argue, the governor's executive orders imposed only a restriction on when a landlord could evict a tenant, making it similar to Yee versus City of Escondido. Since the parties briefed this issue, the Supreme Court decided Cedar Point Nursery, which is instructive in this case. In Cedar Point Nursery, the Supreme Court determined a California regulation requiring agricultural employers to permit union organizers onto their property for up to 3 hours per day, 120 days per year, was a per se physical taking under the 5th and 14th Amendments, the court explained. Whenever a regulation results in a physical appropriation of property, a per se taking has occurred. It is immaterial whether the invasion is permanent or temporary, intermittent as opposed to continuous, or whether the government is directly invading the land or allowing a third party to do so. So yeah, reading that right there, okay? They're allowing the tenant to basically take the property, but the government is allowing it, right? So therefore, it's still a physical taking that is allowed by the government, okay? And the fact that it's temporary, it's a temporary eviction moratorium that lasts 2 years. Well, that's immaterial, okay? I believe this court ruling is correct, but let's keep going. Cedar Point Nursery controls here, and Yee, which the Wall's defendants rely on, is distinguishable. The rent controls in Yee limited the amount of rent that could be charged and neither deprived landlords of their right to evict nor compelled landlords to continue leasing the property past the lessee's termination. The landlords in Yee sought to exclude future or incoming tenants rather than existing tenants. Here, the EOs forbade the non-renewal and termination of ongoing leases, even after they have been materially violated, unless the tenants seriously endangered the safety of others or damaged property significantly. According to Heights' complaint, the EOs turned every lease in Minnesota into an indefinite lease, terminable only at the option of the tenant. Heights has sufficiently alleged that the Wall's defendants deprived Heights of its right to exclude existing tenants without compensation. The well-pleaded allegations are sufficient to give rise to a plausible per se takings claim under Cedar Point Nursery. Yeah, I mean, that's a lot of legal talk there, right? But it should be pretty clear what they're saying, okay? They're saying that, simply put, the government, which allowed the tenants to stay there without paying rent, right? That was an unconstitutional taking under the 5th and 14th Amendment, apparently, too. There's takings involved in that as well. So, it can't be legal. So I hope that this applies to more than just the state of Minnesota. I hope that it expands to, the entire country, because this is important, okay? These eviction moratoriums, they were illegal from the get-go. And anyone with any common sense could see it. It just blows my mind that anybody, any judge, any court would hold this up and be like, oh yeah, this is perfectly fine that, a landlord is forced to house this person without getting paid anything. That is so dumb. I'm like, do you have any common sense, Judge? That's what I want to ask him. I'm like, I want to go up to any judge who thought these eviction moratoriums were legal and be like, okay, here's what I want to do, Judge. I'm going to move a homeless person into your house, right? They can stay in one of your spare bedrooms. Now, you can't remove them. You have to pay to keep them in there. So you have to make sure they have electricity, water, the complete housed environment, and you can't get rid of them no matter what until the pandemic is over. How would you feel, Judge? This is the kind of question I want to ask these judges, because they don't have a clue what it's like for these landlords. And a lot of landlords, they think, oh, well, we're talking about these landlords and they've got hundreds or thousands. No, we're talking about landlords with one unit, with one property. Sometimes it's a duplex. The landlord lives in one unit and the tenant lives in the next one. Sometimes it's a landlord with a single family house who's renting out a spare bedroom and they can't get rid of these non-paying tenants. That's how awful all of this can be. So, yeah, I am glad to read this. Let me skip down a little bit in the article because I'm curious if it says anything about if it will require other states outside of Minnesota to follow, any of what they said. So, okay, it says, even if property owners ultimately prevail in this case and other takings claims against eviction moratoria, it remains to be seen how much compensation they would get. Calculating it may not be easy, and there is likely to be considerable case-by-case variation. Nonetheless, these are important cases to follow. They could well set significant precedents constraining future eviction moratoria and other similar regulations. So what it sounds like is that the landlords involved in this case will be open to sue for compensation for the losses that they took. So I would, we're talking about landlords here who probably have very good bookkeeping records, and I would sue for every single penny. Okay, every penny that it cost me, for repairs, for maintenance, for utilities, for taxes, that I did not get paid, every little bit of rent that I'm missing, everything that I had to, if I had faced any late fees or charges, anything, it would all be part of this lawsuit. Okay, I don't know about emotional distress, but who knows what jury will say is acceptable. But yeah, these landlords, they deserve to be compensated, and I hope that they just sue the pants off of these governments that put this garbage in place.